Welcome to today's webinar, brought to you by OraSure Technologies. Technologies is a global leader in oral fluid substance abuse testing products. Their assays provide accurate and easy-to-administer testing methods to help determine the presence or absence of drugs or alcohol in a person's system. Oral-based testing products provide a simplified collection process, fast results, cost savings, minimal risk of tampering, and dramatically reduced risk of adulteration. Intercept Oral Fluid Drug Test is an FDA-cleared laboratory-based oral fluid drug testing system that enables accurate testing for drugs of abuse, including marijuana, cocaine, PCP, amphetamines, methamphetamines, barbiturates, benzodiazepines, methadone, and opiates. It was the #1 recognized brand name in oral fluid testing in a 2016 National Drug Testing Industry Survey. With an easy-to-administer collection process, Intercept is ideal for workplace, criminal justice, drug treatment centers, and clinical setting screening programs, among others. This presentation is entitled, To Test or Not to Test, Navigating Negligence Risk in the Workplace. For 1 professional development credit from SHRM for those who attend today's presentation in its entirety. You will receive information following today's webinar on how to apply for this credit. Today's presentation will be presented by Nina French of the Current Consulting Group. He is a managing partner for the Current Consulting Group with over 24 years of experience in employee screening. Vice President of Employee Health Programs, Wish Advantage. She specializes in product and business development, occupational health and wellness operations, and drug testing, marketing, sales. She's an expert in all facets of drug testing and employee screening operations, including SAE and compliance monitoring. Her consulting emphasis is on helping employee screening providers streamline operations, launch products, increase revenue, and retain existing clients. It will be our pleasure to hear from Nina French.
The content to go through today, and so we're going to go through slide deck and we're going to hit all of the high points, and as Jessica mentioned, you're going to get copies of this after today's presentation. You'll be able to have the reference slide that is detailed. So what we're going to do is walk through this. We're going to stop and go through some of the slides on specific detail, but what I'd like you to walk away from today's presentation with is an understanding of really the impact of marijuana in the workplace, and then what you as an employer can do to avoid some of the costs and the cost burdens of legalized marijuana for employers. So we'll start with just, some of you have been on some recent webinars and have seen that, 2016 was just a year of change. Drug testing laws and regulations changed across the board. There were 9 states that legalized some form of marijuana. One of the modes of transportation under the DOT modified their random rates. We saw OSHA announce new record and rule-keeping regulations that impacted post-accident drug testing. And then we saw 15 states amend existing marijuana laws. And we have some information on that in today's deck. But really what's important to know is this is a constant change. So drug testing bills are being introduced, and 50%, 54 specifically percent, are about marijuana. There's still other stuff out there. Synthetic drugs are out there, controlled substances in general, and then there's other things that don't touch you as closely, like drug testing. There are a lot of drug test bills proposed, and many of them are passing. And 2016 was a very, very strong year for these drug test laws to pass. And so you have to keep abreast of all of those changes. When we look specifically at marijuana, had a significant shift in the November elections. Pre-November election, this is what the United States look like, with the light green being states that have some form of medical marijuana law, and the dark green have recreational marijuana laws. Right now, I'm going to point out that if you're any of these states that have recreational marijuana laws, have medical before. So the darker green means now you have both. Okay, so when you look at this slide and you compare it to the post-November election, you'll see how significant some of the changes were. And so there are currently 28 states that and the District of Columbia that have marijuana laws on the record, and that's not including ones who have some stuff on just like oils and things. This is the more traditional sense of marijuana laws you think of it as an employer. So we're going to briefly review some of the new laws from 2016. These are not all laws that occurred because of the 2016 election. There's a couple in here that you'll see happened before that. But we're going to review those very briefly, and again, you have a copy of the slides if you want to look at them in more detail. But before we do that, we're going to talk about a very recent Gallup poll from October of 2016, and that shows the Americans today regarding marijuana. And this is going to be important because we need to understand that your mindset, how you apply it, and your concerns about marijuana as an employer, your concerns as a taxpayer, are different than your sort of philosophical concerns. And then the other thing we're going to talk about is, do you really understand it? So 60% of Americans, and this is across the board, right, all age groups. This is not just the college kids saying, yeah, we're into marijuana being legal. This is across the board, from baby boomers down to millennials who are saying, yes, we approve. And the highest percentage of support recorded in the 47-year trend that Gallup was taking polls on legalization of marijuana. Now, that said, I have recently seen other polls where the legalization is supported by as high as 78% of the persons who are polled in the survey. And so what the exact number is on the exact day at the exact moment, it is the wide majority of Americans who are saying we are okay with marijuana being legal. To you as an employer, because it seems that it's okay, everybody's with it. It seems like if I didn't do my homework on it, maybe everybody else did. Or it's the idea of, I don't feel very differently about it. It's not that much different than taking a drink on a weekend. And so as long as they're not doing it at work, it's okay. But we're going to talk to you a little bit today about how that's actually not the case. So marijuana is becoming legal in the United States in a way that is extraordinarily different than any other drug ever, as I can tell. Now, I won't stand on that as ever as 100% sure, but as far as I can tell in the research we've done, never has this happened before. So when you look at the way that drugs become legal in the United States, they have to take a certain route and a certain path. And the path is that they either through FDA because they are a drug, an over-the-counter drug, or a prescription drug. And they through the clinical trials required by the FDA to prove they are safe. Once the clinical trials prove that they are safe, the FDA will allow them to be under very careful scrutiny, manufactured and sold in the United States. And packaging has to specifically designate how you should take it, for what you should take the drug, what the best way to take it is, and the dosage, and specifically what it is for. So many of you have heard of things like off-label use of a drug, and the one I can think of is Botox. Botox was, it's botulism of some sort. I'm not a scientist, right? But, women started using it and men started using it to prevent wrinkles or to hide wrinkles, I guess, on their foreheads, right? Then all of a sudden you hear about people using it for migraines and they're getting it injected in their heads for migraines. That was an off-label use where doctors were doing it routinely, but it wasn't specifically cleared by the FDA for that purpose. So what had to happen is the manufacturer had to go back and perform those clinical trials, show that it was safe for the United States population to use that, indicate any side effects and risks, and then it was able to market it for that specific use. right? So now you'll see the commercials, and everybody's familiar with the commercials where they do the little like super fast spiel of legalese, right, beforehand. They also are familiar with the things that say, do not take this drug if you are taking a inhibitor, blah, 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 right? So not only do they have to package it, manufacture it, and be specific, they have to say, hey, there could be interactions. If you're taking X, Y, Z, then this is going to have a different effect, or we don't recommend that you use it. Marijuana is becoming legal for medical purposes, and it is doing none of those things. And the pro-marijuana legalization movement says that's because it's a Schedule I drug. Well, we're going to talk about what that means, but it is indeed a Schedule I drug, which means it is not legal to manufacture it, grow it, or distribute and sell it in the United States, or prescribe it, by the way. And so we don't have enough of it. It's long, tedious tests. But they're lobbying, if you'll note, to that, right? They're not lobbying to say, hey, federal government, let me go to all these different states and say, make it legal to manufacture enough of the marijuana so that we can get all of these different iterations and all these different types of marijuana, and then we can specifically go through 7 to 8 to 10 years of clinical trials to bring this to market for the specific ailment for which this particular strain of marijuana is good. They're not lobbying for that. They're just getting it legalized across the board. So then we'll skip and we'll say, the other idea is, well, if it's not going to go through that, is it a drug, right? Is it something like echinacea or one of the things that you see on the market that are manufactured? And they go through a different type of scrutiny. And what they have to do is they can go to market under some restrictions through liens, and they go to market and indicate sort of what the uses are for the product. And then it comes about a different way in terms of safety. That if people start to have negative side effects, then doctors or the standard population reports those to the FDA. If the FDA is able to prove evidence of harmfulness, it's after harm has occurred, but if they're able to show the evidence of harmfulness after the fact, then they can have it removed from being sold in the United States. But going down that path either. Finally, say, well, then let's just skip all of this medical stuff, right? And let's just say that it is recreational. It's no different than, a Jack and Ginger or an IPA on the weekend. Well, not following those rules either. So those rules came about after the 21st Amendment, and each state is required to have specific rules and laws, and they govern how it's imported, packaged, sold in their state. The federal government has a hand in it in the fact that they can say, hey, Mr. State, if you don't set out certain limits, like that you cannot drink unless you're 21, or what the legal limits for driving under the influence are, then we're not going to give you some of the federal money we have for roads and parks and recreation. And so generally they do have a hand in it, but each state is able to govern themselves in terms of alcohol and tobacco. But they're not following those rules either. And so it's sort of exploiting the idea that we have to go to market very quickly because there's a lot of people who are sick, and so it's such a miracle drug that we have to go there quickly. Well, it's exploitative because no one gets to do that. There's a lot of drugs that are really beneficial, and people are in clinical trials for those because they are very sick, but still going through a process that we've defined in the United States. And so what we also see is facts being promoted. One of the things we do at CCG is we sometimes look at some of the facts and we trace them back. And it's as simple as Nina French on a website or on a webinar on January 31st at 2:14 p.m. stated that she was 6 foot tall and blonde. And then somebody quotes that I'm 6 foot tall and blonde. And before we know it, it's a fact. And we see a lot with marijuana, where someone states it and it somehow becomes, through this concept of social media and urban legend, a fact, but indeed it's not. So they're pushing these ballot initiatives and they're bringing these drugs to market, and they're really like the West. They're by none of the rules, and really does benefit everybody who's making money off of the pro-marijuana movement, but also how it's not necessarily benefiting us as taxpayers or you as an employer as we go through the next slides. So some of the states just in 2016, Arkansas passed in the November elections a constitutional amendment that legalized medical marijuana for certain medical conditions. The good news is they had specific language and unambiguous protection for employers to continue a drug-free workplace. So you are not discriminating against a person hiring. So you're going to have to establish a little bit of a criteria for your employees before you terminate or discipline them, but there's definitely language within this law that says you can continue to have a drug-free workplace policy and you can continue to enforce it with action up to and including termination of an employee for being positive for marijuana. California's had legalized marijuana for a really long time, but they passed several amendments to the California Health and Safety Code to legalize recreational marijuana. And again, nothing in the section prohibits the rights and obligations of public and private employers to maintain a drug and alcohol-free workplace, and it does not affect the ability of employers to have policies prohibiting the use of marijuana by employees or prospective employees from complying with state or federal law. So lots of chunks of information in that one sentence, but really what it says is if you have a state law, or you have a policy, a drug-free workplace policy, that you as an employer are allowed to enforce that, and the enforcement can be include drug testing, okay? Drug testing protects you if you have a drug-free work policy, but we're going to talk at the end of this about how you have to be very explicit in that policy and how it's written, and some of the court cases that have come about and have to be very, clear in California because they have law. They only have case law, but about safety-sensitive workplaces, privacy, and then the drug testing situations that you'll have in your workplace. Florida passed a medical marijuana amendment, and it said again that you do not have to accommodate the use of marijuana in any place of employment. So again, great to know. It only mentions on-site marijuana use at work. What's not clear about is Florida is one of those states that has voluntary laws. And what it did not describe and is not clear about is how this new medical marijuana amendment 2 sort of affects those existing in the state of Florida. And so what I want you to take away from this slide, the next slide, and the one before it is, all you as an employer, drug-free workplace, though it may be legally correct, what it doesn't do is prevent someone from suing you, right? So having a good policy in place prevents from winning, prevent them from suing in the legal costs. And so again, as we talk about this legalization and everybody sitting back and saying, I'm all for it, that them from suing. It may prevent them from winning. Doesn't them from suing. Doesn't prevent some fly-by-night attorney from taking their case and taking it to you, and you have to hire off-site employment lawyers to fight that case. So Maine, we're not going to go into too much detail, but Maine is very restrictive. So they passed a legalized marijuana for recreational use. It does not require technically employers to permit or accommodate the use in the workplace, but it also doesn't contain very extensive language. So you can't a school, an employer, or a landlord may not refuse to enroll an employee or to lease to blah, 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 solely for the person's consumption of marijuana outside of the employer's property. So it makes pre-employment testing very difficult, but perhaps it's not impossible because the law specifically allows employers to have workplace policies that restrict marijuana use. So again, this is where your policy is to be super specific about what defines use, what finds impairment, and what types of testing you'll be doing in your workplace to enforce your drug-free workplace policy in the state of Maine. It's past question 4, and it allowed for recreational marijuana for individuals 21 or older. Again, that language where the employer does not have to accommodate, and that you can affect authority of, it does not affect the authority of employers to enact or enforce workplace policies. It doesn't specifically mention drug testing. Okay. So sometimes that happens, and that happens with marijuana laws across the board, where they're talking about drugs and drug use, but they actually don't ever mention drug testing. And Massachusetts is one of those cases where it doesn't. So it specifically leaves the matter in the hands of employers to define your drug-free workplace policy and define your drug testing policy. And that's good because it's supportive language. Nevada has recreational marijuana. Again, it says that they're not restricted. And again, it doesn't mention drug testing. And so you can continue to enact and enforce policies that restrict drug use, including marijuana. North Dakota, medical marijuana, doesn't mention workplace at all. The only thing it mentions is that if you're in a compassion center, you have to have a drug-free workplace policy. So it makes no mention. So this is a state where we're going to see changes to theirs to define where the wording of the law is ambiguous. Ohio has HB 523, another medical marijuana law, and it does not require employers to accommodate the use of marijuana in the workplace, and it protects employers against legal action, okay? So that's good news. Less likely to get lawsuits against it when you're sort of got that protection written into the law. And it does not prohibit an employer from enforcing and establishing a workplace drug test policy in a workplace drug-free workplace program or a zero-tolerance policy. Pennsylvania is a little bit, that's where I am, it's a little bit sketchier. So nothing limits the law of the employer's ability to discipline, but then it has a funny little provision in there where it says an employer may not discharge, threaten, refuse to hire, or otherwise discriminate or retaliate against an employee based solely an employee's status as an individual who is certified to use marijuana, so medical marijuana. So the way you can read that as an employer is to say, okay, what we won't do is we say, if you have a medical marijuana card, we are not going to if positive pre-employment drug test, we are not going to hire you. So again, policies have to be super clear, and you have to be aware of what the policies state and how your policy is written to make sure that it now adheres to SB 3 in the state of Pennsylvania. It's no longer a one-size-fits-all policy across the United States. Hasn't been for a very long time. Arizona, Proposition 205. We have this wrong here. I'm seeing we have 206, 205, but it's actually Proposition 205. It failed to pass. What's interesting about Arizona Proposition 205 is it was possibly the one that got the single most play before. Now, the news is that also there were people who were very vocal and very active against making sure it did not pass as it was written. And the concern in a very wide stroke for the issue was that it was written very much like Colorado. And the impact of Colorado legalization has been very strong. And so what the marijuana movement does is they insert language that is ambiguous, and they insert language that specifically can be challenged. And that was the concern. And so really what Arizona proves to us is it isn't done, it's not over till it's over, right? And that it really is a great way to learn what's happening. And you'll see some of the same sorts of information be put into these campaigns for legalization. Sort of think of the children, and think of children with epilepsy. There's a whole lot of propaganda that is pushing through these things. I'm not here to say right or wrong. I'm here to say there isn't a case that has been cured or not. That's not what today's webinar is about. Today's webinar is about being informed and paying attention to specifically what's happening and how these laws are being passed, being aware of the impact that can have on you as someone who lives in the state, or you who has a business in that state. So it's very important for you to pay attention. So let's talk a little bit about today's marijuana and the impact on the workplace. There was a recent study that came out last month in January from National Academies of Sciences, Engineering, and Medicine, and it was 400 pages long. I read it to the best of my ability. It was long, 400 pages. I'm going to reiterate that. And it stated that there is conclusive or substantial research that marijuana appears to be effective treatment for chronic pain, nausea, and symptoms of multiple sclerosis. Okay? Saying, hey, it might be effective. What it also says is there's dangers in it, right? There's an increased risk of car crashes. There's lower birth weight in babies. There's problems with memory. There's problems with attention. They also found strong connections between heavy cannabis use and the development of schizophrenia and other psychosis. This 100 pages, when you read it, really says one major thing, which is coming out before the horse. The cart is before the horse. We don't know. It appears that there are some benefits. We don't know enough. We don't know enough about the dangers. We don't know enough about the risks. We don't know enough about the side effects. We simply just do not know enough. And so what we really urged was that there's more studying done before it becomes more widespread. But again, think back to those slides. It's legally available right now. And so the C supported what we're saying, which is we don't know yet about marijuana. Some things we do know. And again, raise your hand. You're there. We can't see you, right? Raise your hand if you say, I'm all right with it. I was one of the people. Because I'll tell you what, I kind of leaned towards it. And this is what I've done for 25 years. I leaned towards that. I don't know if I think it's that much worse than a drink. Then I started to just realize these details of what was happening. And I thought, okay, wait a second. Well, why did they get to skirt all of these rules? I don't want to available if I don't know what the details are with buying. I know if I have a beer, I can get in my car. I know if I have a glass of wine, I can get in my car. So if I have a bourbon, maybe that's depending on how big of a pour it was, right? I know if I have a shot of grain alcohol, I can't get behind the wheel. I don't know that about marijuana. I don't know which. What we know is that studies have found that the potency has increased dramatically, and that the higher THC content is very specifically linked to some of the marijuana-related emergency room visits and behavior and damage to the brain. In the 90s, you were looking at, in the 80s and 90s, it was like 4%, possibly up 10%. Now we're looking at an average of 20, spiking to 30%, and that is significantly stronger. So what we need to understand is a little bit about what cannabis is, right? And I guarantee you, and this is a pretty weighty statement with all these people on the phone today, guarantee you that if we went out and took a poll of our own and said, explain to us if you understand marijuana, this marijuana that you're so okay with being legal. Explain to us what it is. You know how many active compounds it has? Well, it has about 500 active compounds, and at least 113 of those belong to what the cannabinoids. I'm not a scientist, again, so I try to make these slides and the understanding of this. You know, I'll always get somebody who puts a question into Jessica that asks for very, very specific scientific evidence, and we can dig that up. But my my goal is to make you all scientists. My goal is to help you to understand this from a layman's perspective. Two most common and researched compounds in marijuana are tetrahydrocannabinoid, THC, you're all probably familiar with that, and cannabidiol, which is called CBD. The one that if we took that same Gallup poll, I bet a lot of people don't even know that those two things are in there and what the difference is. They'd know THC, but I bet CBD is making everybody shake their head. They're very from one another, and it's important that if you are going to have an educated opinion about legalization in the country, that you understand what the differences are between these compounds, and you understand, again, why it's strange that we're seeing the THC content go up so significantly as we're seeing legalization increase significantly. So THC is psychoactive. Put plainly, it's what makes you high. Found in cannabis plants only. It is drowsiness, euphoria code for. It causes appetite stimulation, relaxation. It's an analgesic. So it is what you think of typically, dazed and confused, right? If you think of typically, grabbing Doritos, get drowsy. So we know there's side effects. The known documented clinical side effects are drowsiness, right? But there are others that we don't know. Cannabidiol is non-psychoactive. So it does not make you high. It's found in both cannabis plants and industrial hemp. So when you see you're at Whole Foods and you see some lovely hand lotion and it says hemp on it, that is made from industrial hemp, and it doesn't have THC in it. And again, there'll be some exceptions somebody can prove, but that's the general criteria here, right? It is known to be an antidepressant, an anti-convulsant, an antioxidant, an antipsychotic, an anti-emetic. So it does take off nausea for you. It has known medical benefits. There's no bullet there that says known side effects. So again, these both have to be very studied, right? So you're not going to give THC to somebody who's having, you're not going to give something to somebody, you're not going to give CBD to somebody to treat the same thing that you would for THC. And it's interesting that the THC levels are going up, the part that gets you high, but we're not seeing a lot about the CBD levels. And we don't know in each of these different strains, and there's not like one or two, there's thousands of different strains of marijuana on the market today. And what you don't know is you don't see the label, and the label doesn't say this is how much THC there is. Why does it have to be any? Right? Be any. So you could perhaps the medical benefits without any of the THC. But again, this is why the cart is before the horse. What we do know about marijuana right now is that it's the number 2 substance abused in the United States. It's second only to alcohol. Alcohol is legal. We talked about that, right? In 2006, which is the last year I can find the statistics on, alcohol consumption, the excessive alcohol consumption, cost the United States $223.5 billion. And that was 11 years ago. So I assume it went up a bit. So assume the use of marijuana is going to be really on par for that. Where do you think that $223.5 billion comes out of? The United States doesn't have its own little pockets, right? It's taxpayer dollars, employer tax dollars. So you know things, and I'm not going to go through these, right? You know that it's addictive, it impairs a person's ability to operate, or heavy machinery, it leads to more accidents. We are starting to see really interesting statistics come out in states for which marijuana has been legal over the past few years. And so we're starting to see that if a person's under the under the influence of alcohol, their risk of a fatal car crash is 13 times higher than somebody who's not under the influence of alcohol. But we know if they're under the influence of both marijuana and alcohol, right, have some drinks, smoke a joint, their risk is 25 times higher than that of a sober person. Simply means there will be more accidents. Do the math. We know that drug driving accounted for more than 28% of traffic deaths in 2010, up from 16% in 1999. May not seem significant, but it's 12%, people. That's a really significant number. Really significant. And that marijuana proved to be the main drug involved in the increase. It's 12% of the 2010 crashes compared to 4% in 1999. So again, we're thinking about these numbers, 4 to 12, 12 to 16, 16 to 28. It's kind of hard to fathom the numbers, but you have to remember there's more than 300 million people. So do the math. One person you know is too many, and so think about how many people are involved in fatal car crashes because of marijuana use in the United States. Now I'm going to start hitting close to home for employers on the phone. Respiratory issues. Because marijuana smokers tend to take longer, deeper drags and hold the smoke in their lung for longer. Anybody's ever seen it, done it, saw me on it? Take a deep breath and hold it. You're getting more carcinogens or cancer-causing, 50-70% more than in tobacco. So you're an employer, you've considered testing for tobacco use. You know how significant the impact of smoking is. Workplace, CPD, lung cancer, all of the things that cost a ton of money to the United States from smoking tobacco. Get rid of that because 5 times more tar and carbon monoxide is being ingested when people are smoking marijuana. So it just is logical that respiratory issues continue to increase. Memory and learning issues. You know, when a person's high, they lose some of their short-term memory. They have impaired coordination. You're going to see issues with that. You know, just getting tasks done. And that holds true even after high is over. So it changes the brain's chemistry. What we do know is for mental health, and I think this is a super interesting one. Long-term use of marijuana has been linked to increased prevalence of depression, anxiety, schizophrenia, and suicidal ideation. But what I thought was so interesting is that they don't know if it's the long-term marijuana use that causes the depression, anxiety, schizophrenia, and suicidal ideation, or if those already exist, worse because people are self-medicating. And studies just have not been done to that degree. What we do know is it causes inconsistent work, lack of focus, erratic work patterns, increased absenteeism, sort of all of the things that you think about. Additional risk-taking. You know, you might say, I would think that if there's somebody who's got a heroin addiction or crack cocaine addiction, I'm worried about them stealing. It's going to happen too, but not something you think about as much with marijuana. But abuse is drug abuse. And so the statistics that we've seen proven time and time again about the impact of the workplace are going to still be there with marijuana. Positive tests for marijuana in the workplace have increased 6.2% nationally in a period of 1 year. And in those states that first legalized, 20% positive in marijuana in Colorado and 23% in Washington after the state legalized recreational use of marijuana. So the act will hit you if you are doing business in those states. So this is pause and say, okay, we have people, and anyone who's on this phone from OraSure, from a lab, from a TPA, from a background screening company, they haven't had a client come to them and say, we think we're just going to be done, right? We don't it's too much hassle. It's complicated. We don't really feel like getting our policy up to date, and we just don't want to deal with the hassle. Why does that not make sense? So first of all, thing is just from just a strictly sort of standard operating procedure. It's a single point of assessment for an employer, right? You read a resume, you do an interview, and you start to assess, is this person a good match? Because turnover is very costly. And so you do an assessment, and it's a single point of assessment. It is just like doing any other part of a background check. And so it tells you that they either don't use the drug. It's not foolproof, right? It tells you they didn't use the drug long enough to just get out of the drug test. And they researched your company. So there's a lot of things it tells you, but nothing is perfect. It doesn't say, this is a good person or a bad person. It just tells you whether or not they're using the drug. Wanting you to test, increase stability in worker productivity, decrease absenteeism. So some of those things that people think of as soft costs, although I struggle to believe that people think of employee turnover as a soft cost anymore, because when you look at the CAP studies, you see that sort of someone making $30,000 or below is about 20% of their annual compensation to replace them. But when you start to get to paid positions with technical expertise or executive status, and not just like, C-suite executive, we're talking managerial and above, it can cost an employer upwards of 213% of the person's annual compensation, not salary, compensation, to replace that person. So turnover is, soft cost. I don't think it's soft. I think it's indirect perhaps, but it's not soft. So what are the costs? It's increased turnover, litigation, tax liability, workers' comp claims, property damage, company liability, auto insurance, costs, right? Healthcare costs because inpatient and IV programs related to marijuana-related substance abuse are going to go up, right? Increased short and long-term disability claims, increased absenteeism, increased turnover. So all those things are costs to you as an employer. And so as the impact goes up again, you're saying, well, all right, wait a second now. So I test, there's a cost, but even if I have a policy, I'm going to get hit with some of these litigations. Well, so you want to make sure that you are still drug testing to make sure that you keep the employment body that you want. Then you want to have a policy that's super strong so that you avoid losing in any of these cases. But you are still going to be liable for litigation costs if someone challenges you as an employer. And so, there are current questions being litigated across the board about marijuana use in the workplace. So now we're going to switch, and again, I'm not a lawyer, don't even play one on TV, but we're going to switch now to the idea of what the cost of not testing is. This thing called the doctrine of negligent hiring. And so what it really says in a nutshell, and these are not meant to be reference material, look up the cases if you want to know the details, right? But basically the doctrine of negligent hiring and respondent superior is that it applies to an employer's liability for dangerous employees. So respondent superior says it is limited to the employee's act within the scope of his employment. What it really, and negligent hiring imposes liability on an employer when an employee commits intentional tort, often outside of the scope of employment. So we're going to see some cases where both internally and externally there are cases where not testing can cause you more money than testing. The employer under negligent hiring can be held liable for information that you should have known. You might engage in injurious conduct toward third persons. So failing to perform a pre-employment drug screen, to screen for marijuana, right, eliminating it from your panel, or failing to test when an injury or accident occurs, leaves you open for those lawsuits, negligent hiring lawsuits. So in Minnesota's Pontius versus CMS, the employer was held liable because he failed to discover information that could have reasonably been discovered. right? A drug test is reasonable investigation. They were not asking you to do anything that was outside of what is routinely $25 to $40 in the hiring process. So the scope of the investigation, it's directly related to the severity of the third-party risks. Super important to understand that you would then be cost, right? Liable for the cost, you have a good policy, you win. As a lawsuit, you pay for the lawyers and then you pay for the loss. So in the Ohio case, Stevens versus A. Abel Rents Co., the employee committed a violent crime against a customer during the course of employment while under the influence of drugs. The employer failed to conduct a drug test, didn't contact the employee's former employer, and had they done that, they should have been able to see that the person had a drug addiction. And so they were held liable, and Abel Rents stated that the gentleman's drug use, they had known about it, they wouldn't have hired him. There's another case in California where there was a $1.5 million wrongful death and negligent hiring case when a county employee with a history of drug use and juvenile court criminal record murdered her husband. So again, these all point to how important it is for you to conduct a drug test and a background check and a workplace policy that covers both. And there are also cases as we move forward where in the policy, you have to carry it out, right? So you don't want just to have drug-free workplace policy. Then you have to make sure that across the board there's consistency in having it be applied to your workforce and that people are actually doing the drug testing that you have and you say you're going to do. So in addition to negligence in hiring and retention, an employer has a duty to provide a safe work environment. And there's a New York case of Horan versus Cold Spring Construction where the court found that in this case there was a consumption of intoxicating beverages. So this was alcohol, right? But you can apply it to the concept of marijuana. And this is one where the rules existed where they said you can't consume intoxicating beverage at work, but then there was an accident that resulted as a case of it, and it wasn't enforced. So they drank the alcohol in the workplace and the work site, then they left intoxicated, and then there was an accident, and the employer was sued. And the theory was that the employer had not done enough to ensure a safe workplace. So again, you not testing, you not having a policy against marijuana, legal wise in that state, is leaving you open cases of negligent hiring, leaving you open that you're not doing enough to enforce a safe workplace. This is not just for safety-sensitive employees, right? Because it can be trailed backwards and forwards within your organization. And think about it, right? Somebody driving a company car, somebody operating a company vehicle, somebody within the workplace making a large mistake, right, that causes consumers money. There are a lot of different ways that negligence in the workplace doesn't have to do with someone driving a forklift. So there's more cases here. Another case that I see all the time documented was the Safeway case where there was employment, that someone claimed employment discrimination based on disability. He had tested positive for marijuana after a post-accident drug test, and he was terminated. And he claimed that he was disciplined more severely than other people who had tested positive for alcohol. And in this specific case, Safeway's drug-free workplace policy stated that they cannot have a controlled substance on the job or the company premises. And because marijuana is a Schedule I controlled substance, the court ruled in favor of Safeway. So again, nuances of policy and how it's enforced. I want to point out that last week on Monday, on January 23rd, the DOT enforced in their NPRM, which is their Notice to Proposed Rulemaking, that roads are not allowed, right? So they're not allowed to accept marijuana in any form, any medical card as a reasonable or as a prescription medication. So any legally valid prescription under the Controlled Substance Act, they can't have it. And so the DOT, it was really there, but actually just put in even stronger language to state that medical and recreational marijuana in any form will not be an acceptable excuse under the DOT for a positive drug test. And so when you look at marijuana and the profitability that we've all talked about, we've seen that there's a 17.4 increase in cannabis sales, $5.4 billion in the United States last year. You know, the states are making money through tax dollars, the growers are making money, the distributors are making money, marketing, advertising companies are making money, law firms are making money off of the cases. But you're losing money as a taxpayer and employer, and you're leaving yourself open for liability because of these laws. And so if you are not active and aware of the impact, and if you are an HR director or a safety director, we urge you to bring these issues to light and to get active, because it is going to have a direct impact as these laws are sorted through in the courts. It's going to have a direct impact to your bottom line. And so again, what can you do in terms of policy and consequences? USC should state that marijuana is still illegal under federal law because it is a Schedule I drug. And that was reinforced in August of this past year when the DEA announced that they would not, and trust me when I tell you, there's a lot of pressure for them to move marijuana from a Schedule I to a Schedule II drug. And the court said no, they're not going to. You also have to remember that courts have ruled in favor very widely for employers who are seeking to prohibit marijuana in the workplace. And the basis has that it's not protected lawfully off-duty because it's illegal under federal law. And so, again, it really is this idea that this thing has really picked up a lot of steam without people thinking about all of the implications of legality and impact of the legality in these different states. So our best practice is to have a clear company policy. And a clear company policy, as you can get, is a policy, DOT, non-DOT, whichever ones you need, and then state addendums that specifically address these nuances in each of the states. So you want to be sure that your policy addresses the prohibited behaviors, drug testing, when you're doing it, how you're doing it, for what you're doing it, the consequences for policy violations. You want to make sure that the language defines under the influence. It states that the detection of any amount is a violation of company policy, and that a positive drug test results in term work or whatever it is, but it has to be very, very specific in your policy what the consequences are for policy violations. You can still prohibit possession, use, or impairment of marijuana. You can still test under DOT or federal program. You can still test under your own drug-free workplace program. You can use the means and method of your choice as long as you're within the state laws and the federal regulations. And you can discipline or terminate for a violation of drug and alcohol positives in your workplace. So those are things you all still can do. And you can design a program that meets your substance abuse requirements. So OraSure in Intercept sponsors today's test, and they have Intercept that's been on the market for over 15 years. Lab-based oral fluid drug testing, for those of you who are still sort of saying, okay, well, I don't care necessarily if it was done in smoked pot a month ago. Well, then don't do hair testing. Right? If you're looking back for a larger window, then do it. It's a valid testing methodology. But you're an employer who's saying, all right, well, in our post-accident testing, in our pre-employment, we want to look at a tighter window of detection. Oral fluid is a great option because it's a very tight window of detection. And if you look at the positivity rates compared to lab-based urine, lab-based oral fluid testing actually has very similar positivity rates, sometimes slightly higher than urine. And the reason for that is often thought to be what we say is sort of the element of surprise. So when you're sending somebody for a urine test off-site, you're giving them a chain of custody, or you're sending them a link if you're using electronic chain of custody, and you're saying, go take your drug test. You have 24 to 48 hours. And in that time, drug users very often go online and look and see how they can clean their system out, right? They delay to the last possible minute, and then they go and get the test with the hope that any drug that they've ingested has come out of their system. Well, with self-collected lab-based oral fluid using Intercept, you just hand that person at the end of the conditional offer of employment the sort of self-collected supervisor observed device and do it right there. And they don't have the time to water hydrate. They don't have the time to look at adulteration methods. I will say there's been, any of you who've been online recently on LinkedIn, a lot of talk about adulteration with oral fluid. And we're going to see that, right? So as we see oral fluid gain popularity, as we see it become approved for DOT testing, and we saw a little bit of that because on the same day the DOT announced the notice of proposed rulemaking, the federal government, DHHS, did revised mandatory guidelines. And in their revised mandatory guidelines, they opened the window for oral fluid testing, lab-based oral fluid testing, to be introduced. It's not there yet, but they said in a federal program, that's not DOT, guys, that's federal. It's not DOT yet, right? But in a federal program, they said that you can use oral fluid or an alternate substance when someone is not able to produce enough of a quantity of a urine specimen. So it's, it's open that window, and it's a great detection, and it's a good indicator of recent use. So for post-accident testing, you can still do post-accident testing, and it's great because it does show, because you've got a shorter window. So it's like 24 to 48, 18 to 24 to 48 to 36, but we're a short window of detection. So it is easier to link to recent use than some of the other testing methodologies. It's able, as Jessica said in the very beginning, to detect expanded opiates, and that's another whole conversation, whole training about how influential that is on our workplace and the cost. It's easy to budget because if you're self-collecting, it doesn't matter if you have remote employees, as long as you've got someone to serve the collection process, you can say across the board that it's a standard price, and you're not worrying about fluctuation because of different collection facilities collecting. So it's easy to budget. And if you're a third-party administrator on the phone, then it's really an option for you to think about offering to your employees, because it allows you to be able to give a national price across the board for a national employer. And so there's a lot of reasons to look at considering lab-based oral fluids. It's also something that's available in between 47 and 48 states, and it's sort of the same states that cause you a little bit of trouble. We are going to see that as the federal guidelines change, that change as far as oral fluid to the positive, because the some of the states or the voluntary laws that restrict oral fluid testing, only because they forgot to mention or realize that when we follow the federal guidelines, they accidentally sort of excluded lab-based oral fluid. But now that that's something that'll be available, and we'll see that open up as in October for some of the additional states. So as legalization goes, ARC is a seat at the table now. One of the largest costs in your company, and you in HR and safety are, obligated to look at your bottom line. I've been in HR in some form or fashion my whole career, and people used to think about it as like the soft people. No longer is that, and it hasn't been for 10 years. And so you've got to think about getting educated, educating yourself, and becoming active. Stay aware of the legalization efforts. Get active in your state. Look at what the pro-legalization folks are saying and make sure it's coming from a valid source, and be active in the movement, because it's going to cost you money. And then look at the data that you have. If you're doing the drug testing now, look at it and continue to test and see what the impact is in your state. Statistics are coming available now. It's important that you look at them and you use them and you analyze the impact in your individual workplace and the costs of it. And so one slide in here just really about how to contact your lawmakers if you are going to get active, because what you don't want to happen is to find out that these things have passed and now the lawsuits are sitting on your lap. You want to get very active in sort of, if you get legal, right, go about it the right way so that it not cost employers additional money. So questions, we are seeing questions come in on the board. We're not going to have time today to answer questions. It's very difficult with an audience of this size to answer questions. I'm going to reiterate that you'll get information you'll get the slide deck, because that question comes all the time, 100 times. You will get the slide deck. You will get information on how to get your CEU credits. And we appreciate OraSure for sponsoring today's webinar. We appreciate all of you for attending, and we hope that the information provided you with, that the webinar provided you with information that you can walk away from today and feel like you are more educated than you walked into an hour ago, and that you're comfortable looking at options for testing in your workplace, and that you're comfortable understanding the costs and the impact of not testing, and realize that that is not an option that makes sense, and that you have to be active so that you can contain the costs and the liability for your workplace. So with that, Jessica, I will turn over the mic to you.
Thank you so much, Nina. And on behalf of OraSure Technologies, we hope you have found today's presentation informative and helpful. This presentation was recorded, and you will receive instructions informing you how to access the recording. Additionally, the presentation qualifies for 1 professional development credit from SHRB for those who have attended today's presentation in entirety. You will have information following today's webinar on how to apply for those credits. Thank you for your attendance today, and this concludes today's webinar.